But moving on to our next speaker, Maureen O'Hara, whom we know very well because she's a member of WDI as well. She's a legal academic and radical feminist activist. Her activism focuses mainly on defending sex-based rights and challenging the sex-trade exploitation of women and children. She is a co-author of the Declaration on Women's Sex-Based Rights. And Maureen has a talk with the title Child Sexual Abuse, Denial, Minimization, and Victim Blaming, which links very well with the previous talk by Susan. So Maureen, thank you very much for being here, and over to you.
What sparked off this webinar really, and our decision to have it, was a lot of the discussions that have come about in the public domain in relation to the what I generally call grooming gangs. I think they're more accurately called pimping gangs because that's what they are. They were pimps. So they're all pimps. They all traded girls. They sold girls to the men. And that's something that, as Anna pointed out, often gets overlooked. And in the UK, the recent discussion was partly sparked off by the uploading to social media of a court document relating to the rape and pimping of girls and young women in Oxford. It was the judge's sentencing remarks, which Anna's already mentioned, and those sentencing remarks discussed some of the assaults and young women talked about in some detail and described them. It was published in 2013, but it's only been relatively recently, I think, that many people have seen it because it was uploaded on social media. And sentencing remarks aren't generally, made available so easily to the public. The girls were deliberately degraded. Beyond the sexual assaults, there were other types of degradation which were very deliberate and carried out by groups of men. And on some occasions, they were abused in particularly sadistic ways. And I think that, partly because of that, the so-called discussion of the so-called grooming gangs has caught public attention in ways that other forms of child sexual abuse haven't. People were shocked and horrified, I think, by the abuse described in the judge's sentencing remarks. And I think that some of them reacted as if the extreme forms of abuse detailed by the judge were unique to that particular form of child sexual abuse and to gangs of that kind, to organised abuse of that kind. But they're not unique. And the forms of abuse that Anna's already talked about and that Sue's already talked about show that. Sexual abuse of children in other contexts often involves deliberate degradation of different kinds and sadism. The report of the independent inquiry into child sexual abuse, which was published in 2022, that was a national inquiry in the UK, very wide-ranging, and it looked at a lot of different types of sexual abuse in different contexts and spoke to many survivors. And it states that the accounts of victims and survivors who were heard by the inquiry showed that, and this is a quotation, many of the acts perpetrated caused agonising physical pain. So sadism, deliberate causing of extreme pain, is often a feature, often happens in child sexual abuse. It's not unique to one particular kind of sexual abuse. Survivors of child sexual abuse and those who work to challenge it, whether as activists, practitioners, or researchers, know this. They're familiar with that information. But many of the general public don't. And so I think many of them who did read those sentencing remarks were very, very shocked. Rightly so, and understandably so. But I think what the public needs to know is that this is widespread, and this type of sadism and this kind of extreme abuse of children takes place in many, many contexts. And all of those contexts need to be publicly discussed and challenged. If we're going to be able to seriously challenge child sexual abuse in all its forms, the public need to know how prevalent it is, and they also need to understand its root causes. And as with sexual violence against women, its most significant cause is male dominance. Sexual abuse is a way to exercise dominance, essentially, and its perpetrators are overwhelmingly male. Whether it's committed against children or adult women. The 2019 crime survey for England and Wales found that 92% of respondents to the survey who'd been sexually abused in childhood said that those who had abused them were exclusively male. They weren't all adult men. Abuse by children, and particularly boys, has been increasing in recent years. In 2021, the crime survey showed that between March 2017 and March 2020, 98% of those who had experienced rape since they were over 16 reported the perpetrators were male. As I've said, the sexual abuse of children in the UK is increasingly perpetrated by other children, usually boys, who now have easy access to online pornography showing the abuse and degradation of women. And that's something that should also be a national scandal and widely talked about, but it hasn't been. A large proportion of child sexual abuse occurs in the family environment. And according to a report into intrafamilial child sexual abuse by Sarah Scott, written for the Centre of Expertise on Child Sexual Abuse, that accounts for almost half of the child sexual abuse offences reported to the police in the UK, or rather in England and Wales. Those figures relate to England and Wales specifically. And most of the abusers where abuse is carried out within the family are male. And that includes other children within the family, often older brothers or other male relatives. Sexual abuse often takes place within institutions, and that's something Susan's talked about in relation to Frank Beck, and those include churches, schools, sports clubs, children's homes, secure accommodation for children where children can be very vulnerable. It's perpetrated by organised networks, including pimps who make money from the sexual abuse of children in the sex trade, whether in prostitution or in pornography, which is now more commonly called child sexual exploitation. And increasingly, it also takes place online. While class and cultural factors like religion play a role in shaping the patterns sexual abuse takes in particular contexts, and that was the case with the grooming gangs, about whom there's been a lot of discussion recently, but I'm not saying that their cultural and religious beliefs were irrelevant. But I think the key driver of what their abuse of children, and the key driver of all abuse of children, is sex-based oppression, it's male dominance. The nature and the prevalence of child sexual abuse was first brought to public attention in the UK by feminists, who at the time broke a long-standing taboo about talking about it publicly. The first feminists to talk about it were the First Wave. I was probably talked about earlier, but the first wide-scale discussion was during the First Wave in the 19th century. And those feminists campaigned against the sex trade and the sexual abuse of children. They campaigned, for example, for the age of consent to be raised. It was 12 at the time of their campaigns. It then was raised to 14, and it's now 16. And they also understood very clearly the links between the sexual abuse of children and the sexual abuse of women in the sex trade in particular. The knowledge they brought to light, though, was largely lost in the first part of the 20th century. And then it was again brought to light by second wave feminists in the 1970s and 80s. During the second wave, many women met in women-only groups for the first time and began to talk about their experiences of sexual abuse, including their experiences as children. Rape crisis centres and refuges for women and children escaping domestic abuse were first set up in this country by second wave feminists. And within those spaces, women started talking to other women without the presence of men, often for the first time. And they talked about their own experiences of abuse, including child sexual abuse, and also their children's experience of sexual abuse from their abuser. So that was one of the reasons, one of the things that fed feminist campaigns against sexual violence and led to feminist campaigns around child sexual abuse, which were quite common in the 70s and 80s. The true extent of child sexual abuse is impossible to measure because most children don't report the abuse when it's happening, and only a minority of adults report it to any official agencies once they reach adulthood. There have been two major prevalence studies in the UK, well, in England and Wales. I keep saying the UK when really the data relates to England and Wales, which is a separate jurisdiction from Scotland and from Northern Ireland. Those two studies were carried out by the NSPCC and the other by the Crime Survey for England and Wales, which is a regular survey asking people about their experiences of crime. They reached very different estimates. Those two studies were reviewed by Karika Karsner and Liz Kelly for the Centre of Expertise on Child Sexual Abuse in 2021. And they concluded that, taking into account the variations in prevalence study data in England and Wales, overall it suggests that 15% of girls and young women and 5% of boys and young men experience some form of sexual abuse before the age of 16, including abuse both by adults and by under 16s. They also say that that's likely to be a very significant underestimate. They say that official data vastly underestimates the scale of child sexual abuse because most of it remains hidden, is not reported to any official agency, and it's not uncovered usually while it's happening. Where it is reported, that's often when the victim survivor is an adult. Not all suspected cases are recorded, and not all reported cases are visible in the published data, whether that's in criminal justice data or child protection data in the civil law context. And also recording practices vary a lot between different agencies and between different geographical areas, and they vary over time. But one thing that all researchers seem to be agreed on is that the data that we have usually underestimates the extent of the sexual abuse of children. And the Crime Survey in England and Wales, which I mentioned earlier, asked people about their experiences of child sexual abuse and found that 1 in 5 of those who said they were sexually abused as children had never previously told anyone until they spoke to the people carrying out the survey. Less than 10% had told official agencies about their abuse at the time it was happening, and about 25% had reported it to agencies at a later date. The most common reasons that people gave for not telling anyone were embarrassment, fear of not being believed, and fear of humiliation. And fear of not being believed and fear of humiliation are very well founded because that is, in many cases, if not most cases, what's likely to happen to them. Like all forms of sexual abuse, the sexual abuse of children is enabled partly by denying its existence, denying how commonplace it is, minimizing its significance, and blaming its victims or framing them as liars. And that has happened historically throughout most institutions. Today, no one can plausibly deny that child sexual abuse exists at all. So what is often denied is how prevalent it is, how universal it is, in fact. It's committed by men and increasingly boys of all ethnicities and religions and all class backgrounds. And one way that this can be explicitly or implicitly denied is by framing it as being committed mainly by men from particular backgrounds. Focusing mainly on a particular group of abusers on the basis of their ethnicity or religion can be a way of denying the universality of child sexual abuse and also denying that its roots are in wider male dominance within society. And I think that's been happening with some people in the recent debates in the UK. That many of the people talking about the pimping gangs have focused almost exclusively on the fact of their religion and their ethnicity. I've said very little about the male dominance involved and any links to other forms of male dominance and dominant male behaviour in other contexts. Another way in which the universality of child sexual abuse is denied is by framing abusers as a distinct group who are fundamentally different in nature from other men. And one of the ways in which this happens is by calling men who sexually abuse children paedophiles. That's often used in a way which implicitly or explicitly suggests that they are exclusively sexually interested in children and are therefore different from the majority of other men. But that's not true. Most men who sexually abuse children have relationships with adult women who often they also abuse, either sexually or in domestic abuse, or both. And some have relationships with other men. And many abuse both children and adults. Amongst the most common forms of abusers are men who abuse within the family, and they often abuse their own daughters or other family members. Those are men with adult relationships, their fathers. So their interest sexually is not exclusively in children. And I think the use of the word paedophile to talk about all men who sexually abuse children, rather than limiting it to those who have an exclusive interest in children, and there are men who are like that, and tends to obscure how universal sexual abuse is. If we don't see the universality of child sexual abuse and the significance of male dominance in giving rise to it, we can't fully understand it. And if we don't fully understand it, we can't develop effective strategies for preventing it and challenging it. To understand child sexual abuse, we need to see its connections with men's sexual abuse of women. They're both part of the same continuum of male violence. The pimping of children in child sexual exploitation isn't separate from the pimping of adult women. Both are integral to the sex trade. In the 19th century, in upmarket brothels in England and Wales, young girls were auctioned, publicly auctioned within the brothel, and were marketed as virgins. This was to wealthy men from often the higher echelons of the establishment, many of whom frequented brothels, particularly in London. And those were brothels who were particularly aimed at that clientele. At that time, girls, usually working class girls, were traded between men as openly as adult women. There was no welfare state and few laws which could be used to protect children from sexual abuse. So the links between the sexual exploitation of girls and women by the sex trade are now less obvious, but many pimps still coerce and exploit both girls and women, and sometimes boys. Many sex buyers actively seek out girls and young women. I know this because I grew up in a red light area, and it's absolutely the case. Every time I went out of the house for a period of a few years, from the age of about 13, I was harassed by sex buyers. And they targeted young women and girls. They have a particular interest in young women and girls, but not an exclusive interest. They're not paedophiles, but they have a particularly strong interest in young women and girls. And pimps target young women partly for that reason. They can make more money from them. And because they're often easier to manipulate and control than adult women. Pornography, which is created from the sexual abuse of children, now often called child sexual abuse images, is an integral part of the wider porn trade and is often marketed by the same organisations. According to a 2021 publication by CEDAW UK, which campaigns against the sex trade, they published a document called Expose Big Porn, and they talked about the search tags that are allowed or were allowed at the time by Pornhub, a massive purveyor of pornography online. And those search tags included babysitter, young, virgin, little, tiny, extra small, and barely legal. The document or their report also lists the titles of some of the videos, but I don't even want to repeat the names of them, so I'm not going to. But the search tags give you a pretty good idea of what the men using Pornhub were looking for. And Pornhub was quite happy to provide it for them. Some of the images that in those videos are adults dressed to look like children, but much of the porn that was up there was actually porn involving the sexual abuse of actual children. The links between adult and child pornography are rarely explicitly recognised in public discussions. The change of wording from child pornography to child sexual abuse images is helpful in one way because it makes the nature of the images very clear. But at the same time, it's helped to obscure the links with adult prostitution, so adult pornography, sorry, in much the same way as the change from using phrases such as children abused through prostitution, which used to be used in the 90s, to child sexual exploitation has helped to obscure the links between the prostitution of adults and of children. And I don't think it's any accident that those links are being obscured. The fact that these connections between the sexual abuse of children and of women are not widely recognised is one aspect of the denial of the nature of both child sexual abuse and the sexual abuse of adult women as an expression of male dominance. Other forms of denial come into play when children report sexual abuse or adult survivors report it and seek accountability from their abusers. The general public have been shocked by the fact that the agencies which should have protected the girls who were sexually exploited by pimping gangs and should have held their abusers to account often didn't do so. Social services and the police often denied that the abuse was taking place or minimised it by seeing it as consensual, even though many of the girls were below the age of consent, which is 16 years, and they'd specifically reported rapes and other sexual assaults and described them. The inquiries into child sexual exploitation by organised gangs in Rotherham and Rochdale describe the police as blaming the girls and young women who reported abuse. They looked down on them and saw them as slags, which is a term of abuse for women seen as loose, for anyone who's not familiar with English slang. Their contemptuous attitude was partly related to the young women's class backgrounds. They looked down on them for that reason as well. And the public are rightly shocked by these institutional failures, but many don't realise that this kind of response from institutions also happens in relation to other forms of sexual abuse. And Susan has described that very well and the ways in which it can happen. The independent inquiry into child sexual abuse states that the inquiry heard how difficult it was for many victims and survivors to report what was happening to them and how many were ignored or not taken seriously. One of the areas which the inquiry looked at was abuse within institutions, and among others, they looked at the response to allegations of child sexual abuse on the part of clergy in the Roman Catholic Church in England and Wales and in the Church of England, and in the response to the abuse of children in local authority care in Nottingham City Council and Nottinghamshire County Council, and also in Lambeth Council, and Lambeth is an area in London. And the report said that common themes relating to institutions were that the deviousness and cruelty of perpetrators was limitless. Children were threatened, beaten, and humiliated. Those with disabilities or other vulnerabilities were often deliberately selected for that very reason. And the data suggests there is a higher rate of sexual abuse of children with disabilities than of other children. And the report goes on to say, protection of personal and institutional reputations above the protection of children was a frequent institutional reaction. Statutory agencies were not informed, perpetrators were moved on, and there were failures by those in authority to thoroughly investigate allegations. Records about child sexual abuse allegations were not kept. And that was widespread throughout many different institutions that the report looked at, or the inquiry looked at, I should say. One of the inquiry's case studies related to a Church of England bishop called Peter Ball. He was cautioned for gross indecency in 1993, and then a caution is like a warning. To receive a caution for a criminal offence, you need to admit that it happened, but it's not the same as a prosecution. And he pleaded guilty to further offences in 2015. Those included indecent assaults, and he admitted abusing his position as a bishop to sexually abuse 17 teenagers and young men. One of the young men, Neil Todd, ultimately committed suicide. And the inquiry states that at the time, the church discounted Bell's behaviour as trivial and insignificant, displaying callous indifference to Mr. Todd's complaints. The inquiry also looked at institutional responses to allegations of sexual abuse and exploitation involving people who were publicly eminent. And it states, several cross-cutting themes recurred throughout the investigation, including undue deference by police, prosecutors and political parties and others in public life, differences in the treatment of wealthy and well-connected individuals as opposed to those who are poorer, more deprived and without access to networks of influence. And that's very clear from what happened with Frank Beck. Professionals' responses were influenced by the class backgrounds and the social status of victims and of survivors and of alleged perpetrators. And that's the theme of many inquiries into child sexual abuse. One institution with a long history of denial and minimisation of child sexual abuse is the criminal justice system. There have been serious attempts to change attitudes within the police, the Crown Prosecution Service, and amongst the judiciary in recent years, and they've been successful to some extent. But traditional attitudes still linger. Till 1994, something known as a corroboration warning was required in all sexual offence cases under the common law. That's law made by judges rather than by acts of parliament. This was a warning that the judge had to give the jury that it was unsafe to convict a defendant in a sexual offences trial solely on the basis of the uncorroborated evidence of the complainant. The complainant is the person bringing the allegation. The warning applied to both adults and child complainants, and if it was not given, the defendant would automatically have the right to appeal. Corroboration is independent evidence, which is independent of the word of the complainant. The requirement for the corroboration warning was essentially an expression in law of the view that women and children frequently lie or fantasise about sexual offences being committed against them. And it was often given in a way which explicitly expressed this. This is an example of a corroboration warning given by a judge at the Old Bailey in 1976. He said, "It is well known that women in particular and small boys are liable to be untruthful and to invent stories." And the corroboration warning was often started with that phrase, "It is well known that." They thought it was well known because it was constantly stated by other judges. In fact, it's nonsense, and it's very clear from research that false allegations are very rare. They do happen, as with any type of criminal behaviour, but they're very, very rare in relation to sexual offences. In addition to the corroboration warning, a range of common law rules made it difficult for young children to give evidence at criminal trials. They were often seen as not competent to do so. That was changed by the Youth Justice Criminal Evidence Act 1999, which states that a witness of any age should be seen as competent to give evidence unless it's proven that they're not competent. But the position before 1999 meant that very young children wouldn't be allowed to give evidence, and therefore they could be sexually abused with impunity. There was no comeback in the criminal law because the children couldn't give evidence. So unless the sexual abuse of the child was witnessed by somebody else who was willing to report it, it would not go to a criminal trial. Law and guidance relating to child witnesses has improved significantly since the 1999 Act. But giving evidence about child sexual abuse is still an ordeal, which is often made worse by the cross-examination tactics of defence advocates. In his sentencing remarks in the Oxford case, the judge said, "Each of these 6 young girls have shown enormous courage in coming to the Old Bailey to give evidence, knowing that they would be accused of lying, knowing that they would have to relive their ordeals, knowing that they have not been believed by the authorities in the past." When a defendant pleads not guilty, it's inevitable that the witnesses giving evidence against him will be accused of lying, or at least of being mistaken. But there are ways in which defence lawyers have traditionally cross-examined witnesses which have been extremely traumatic for those witnesses, particularly in trials involving sexual offences. The central purpose of adversarial cross-examination is to undermine the credibility of opposing witnesses. And research studies identified strategies for doing this, which are frequently used by advocates across different common law jurisdictions, all of which have adversarial systems. Louise Ellison, who's a legal academic who studied different types of ways of giving evidence, has said that victimological study of criminal trials proceedings has revealed the extent to which cross-examination is used as a tool to humiliate, intimidate, and confuse opposing witnesses. These practices have been gradually modified since the 1999 Act and the guidance which was written to accompany it, particularly in relation to child witnesses and vulnerable adult witnesses. And that includes witnesses giving evidence about sexual offences. However, defence lawyers still use them when they think they can get away with it, often, as the following quotation from a QC, the criminal QC, shows. He said, "But there are barristers still who defend who simply want to destroy a complainant." And I mean that. They know that if they can turn her into a snivelling wreck or make her look a complete tart, they will win their case. And it's wrong. And Section 41 is talking about the 1999 Act, has gone a long way to stopping that. But people still try and do it because that's the way. That's quoted in a book by Jennifer Temkin called, and Barbara Crahay called Sexual Assault and the Justice Gap. Question of attitude. Now, he was speaking in 2008 and things have improved considerably since then. The kind of strategy will probably evoke disapproval from juries if it's used with very young children, but it can still be used in subtle ways, or relatively subtle ways, when the complainant is an adult woman or a teenage girl. And it is still used in more subtle ways than that particular barrister described, but it still happens.
Excuse me, you're very close to your time, so maybe you could wrap up for. Thank you.
How long have I got? Sorry, I haven't properly kept track.
Well, you're over, but I think you have a minute or two to wrap up. Yes, thank you.
All right, I'll wrap up. Okay. Okay, just to finish, and in relation to allegations of rape within the criminal justice system, for many years there's been a very, very low conviction rate for rape in particular. Of the rapes reported to the police, an average of about 1 to 5% result in a conviction. Cases drop out along the way, either at the police stage, the Crown prosecution stage. They often drop out before trial. When they reach trial, the conviction rate is not significantly lower than with many other types of sexual offences. But what happens is that they're filtered out at the earlier stages, and what helps to filter them out is police views and Crown prosecutors' views of which women and girls will be seen as respectable and credible by juries. And that's still happening. It's still, although probably less the case now with young children in particular than it is with adult women and teenagers. The conviction rate for child sexual abuse offences is relatively high once they get to court. For many offences, the lowest conviction rate is for rape, as compared, for example, to the production of child sexual abuse images. So the lowest conviction rate is for rape, and that's partly, I think, because of the reasons that Anna referred to in relation to issues of consent coming up, where defendants are accused of raping under 16s, even though they can't validly consent to sex in law. Issues of consent and the defendant's belief in consent still arise. And where that happens, I think that might explain the reasons for the relatively lower conviction rate for rape as compared to other types of child sexual offences. But I'm speculating. I don't know whether that's really true. But I think it is true that there are still a number of difficulties in even getting a case to court, and that relates to the attitudes and the stereotyping of girls and young women that occurs in the earlier stages of the proceedings, where the police decide that a young woman or a girl won't be a reliable witness, or the Crown Prosecution Service decide that. Factors like whether she'd been drinking at the time are things they take into account. And research shows that's something that juries take into account as well, and they tend to have more victim blaming attitudes when women or girls have been drinking. So all kinds of stereotypes and rape myths are still coming into play, particularly at the earlier stages of the criminal justice process. And what happens is that the witnesses who are seen as most likely to succeed in convincing the jury that they're telling the truth because they're seen as more respectable, are the ones who tend to get to court. And once they get there, the conviction rate is not significantly lower than for other offences, but many don't ever get there because of rape myths and sexual stereotyping. Thank you. I'm sorry for running over.